Hello, everyone. Thank you all for joining us today for our Performing a Complete Vendor Contract Review webinar. My name is Jessie Redmond, and I will be your host. On your screen, you should see multiple widgets that you can use, including Ask Question, Media Player, Slides, Related Content, Speaker Bio, Request Demo, and Help. If you're unfamiliar with our webinars, all the widget boxes are resizable and movable, so feel free to move them around to maximize your screen space. At the bottom of your screen in the toolbar are icon buttons you can use to show and hide the widget. You can expand your slide area or maximize it to full screen by clicking on the arrows in the top right corner of the widget. If you experience any issues or have technical questions, you can use the Help widget or submit them along with any other questions through the Ask Question widget. Don't worry, we do capture all questions throughout the session. We will answer some during the webcast, but those that we do not have a chance to answer live, we will address with you via email. Today's live session is eligible for 1 CPE credit. If you wish to receive this credit, please remember to be logged in individually with your own credentials, answer all 3 polling questions that appear on your screen during the presentation, be in attendance for the entire live 1-hour session, and complete the follow-up survey. We will send the link to that follow-up survey 24 hours after this live session. If you meet all requirements, we will send your CPE certificate within 7 to 10 business days following survey submission. With us today, we have Kelly Vick, VendMinder's president. She will walk step by step through how to review a vendor contract. Kelly will also discuss key contract terms and conditions to include clauses and sample language, and how your organization's exit strategy fits within vendor contract management. You will see a link to today's slide deck, a link to our website, a link to our samples library, links to our How to Write Fourth-Party Vendor Requirements into the Contract infographic, our What to Consider for Vendor Contract Renegotiations or Amendments infographic, How to Develop Metrics in Your Third-Party Risk Management Program infographic, as well as a link to our library of additional resources, all in the Related Content widget. With all that being said, I would like to hand it over to Kelly. Kelly, the floor is yours.
Thanks, Jessie. And in today's webinar, we are going to cover the key elements of a vendor contract and addressing fourth parties in those vendor contracts, talking about key performance measurements and indicators. We're going to talk through how exit strategies are important, and we'll cover some common contract language and clauses, and then we'll end it with key takeaways. So let's go ahead and get started. Okay, so let's start by reviewing the 5 phases of vendor contract management. First phase is internal planning. You're going to work through who should be involved in the selection of the vendor and who has the authority to put an agreement in place with that vendor. So there probably are multiple people involved in that process, so you want to make sure that you have all collaborators involved from the beginning. And then phase 2 comes in negotiating, creating, and drafting of that agreement. Will you be working with a standard contract template? Maybe you have one that you're going to lead with. If there are red lines to that, or you're looking at an agreement from the third party, who has a responsibility to approve changes, who is responsible for creating the contract, who has that final sign-off. Phase 3 is approving and executing. So now once you've negotiated that language and the parties that were involved approved the changes to any language, agreed with what language might come out that we would typically have in our agreement, now it goes to someone who has the approval to actually put that relationship in place and sign on the dotted line. And then you want to, in phase 4, know where your contracts are housed. And I can tell you that's not always a simple thing. So hopefully you have a centralized location where all of your contracts are stored. And then lastly, phase 5 is managing the contract. Who is managing that contract through the life of the relationship, because that contract needs to be managed just as the third party needs to be managed. So contract negotiation is something that should always happen. Even if you are presented with a third party who states You must accept our contract as is. No changes are acceptable. There's still an element necessary for you to understand what you're agreeing to. If you just have to do that and you want to do business with that third party and that's just the way it is, and go into that knowing what it is you're agreeing to. But if you can negotiate language to ensure that you get the contract language in the contract to cover the risks that you identified with that vendor, the risks that are important to your organization, to ensure that you are covered thoroughly, then this is something that absolutely needs to occur with every contract that is negotiated, including replacement, renewal, modifications, amendments, all of those contracts. The contract language should be negotiated at all times. Okay, so we're going to cover over the next several slides some critical elements or provisions that need to be included in your vendor or third-party contract. And from my experience, what you typically find in contracts are two documents. One is the Master Services Agreement, or MSA, that typically outlines the terms and conditions, the legalese, the legal language. The other document is what's outlining the particular purchase plan for that particular product or service, sometimes called an order form, sometimes called a statement of work. It could be any number of things, but whichever way it is, it's very important that within the SOW and the MSA that you're clearly outlining and identifying the scope of the relationship. And so you're going to address things like, what exactly are you buying? What will the training look like? What is the onboarding and implementation process and timing? What responsibilities do each party have in this process? How's it going to be supported, and pricing and payment details. So clearly identifying the scope of what is being purchased is one of the most important parts of getting the contract established. So as we talk through these, I don't want to suggest that your contract should flow in this order. It's just a matter of putting them in this order. But first, you want to make sure that you locate performance standards. And I want to point out here, too, that don't assume that, especially if you're working with the third party's contract document, that it will automatically include SLAs, but if you want them, you need to make sure you insert them. We're going to talk about performance standards as part of this webinar, so I won't spend a great deal of time on that. And then the really important one, to ensure that you have detailed out succinctly, are the termination and notification requirements for the contract. It's this is, you know, one that when it comes time to end the relationship needs to be very clear on what the expectations are on how you can get out. Does it auto renew? If it does auto renew, what's your notification period? How do you have to cancel? Those kinds of things. So that is a very important clause to have detailed out correctly. So security and confidentiality are significant and critically important topics to include in your contracts. Again, especially with your critical and high-risk vendors, but I would suggest that they are important for any of your contracts. It's important that this language be written so that your data is protected and secure at all times. It's very likely that you may be encountering a DPA or data processing agreement as an addendum to the contract, because that has specific requirements and regulations that it's covering, such as GDPR, CCPA, and other relevant privacy laws. So you could see an addendum that addresses some of this in addition to the provisions that are in the MSA or the terms and conditions document. But regardless of how you sign them, the things that you're going to be looking for is, the third party plans to safeguard your data upon rest and upon termination, how they plan to prevent exposures to breaches, what their breach responses are, their response time and how they handle it, how they protect your data against threats and unauthorized access, how they log incidents, how they manage credentials. These are just a variety of things that should be covered. This is a very, very large topic, and I'm certainly not doing it justice with this 2-minute conversation about this topic, but this is certainly something that needs the right people in your organization reviewing when you are negotiating the contract. Okay, here are three other critical elements to talk through. One, look for audit requirements. Again, if this is a critical vendor performing a critical service for you, you probably want to ensure that you have the right to audit, whether that is an on-site physical audit or an audit of certain documentation, certain reports, etc. But be sure that is covered. Speaking of reports, if there's a requirement for reporting as part of the contract, maybe as part of the SLA, wherever it might be sure that that is covered as far as what the expectations are, as far as what the report is, what it covers when it is made available to you, and then compliance with laws and regulations. And of course, this is a pretty standard clause in every contract, and it will be dependent upon the industry that you are in, that your vendor's in, the regulators, the location will be dependent on all of those things. For those vendors, again, that are providing a critical service to you, and especially for those vendors who have a meaningful impact on your customers and have access to your customer data, you certainly want to ensure these two elements are in your contract. One is about business resumption and contingency planning. You will want to ensure that the vendor has a program in place for doing routine DR testing, providing you the results of that testing, providing you with annual documentation, due diligence documents around what their process and their requirements are for that. And depending on how critical that vendor is, especially those that you pay a large sum to, it may be a requirement that you are included in that process. And then another critical element is around their subcontractors, the fourth parties to you that are also critical in providing that service to you and have access to your customer data. We're going to be covering that deeper after the first poll question. So for right now, just know that that is an element that should absolutely be included in your contract language. So let's talk about ownership and license information and reps and warranties. Again, these are just standard contract language that you're going to have in place regardless of the type of vendor and the type of contract. But it's important to make sure that your rights are protected and outlined within the contract as far as ownership and licenses go. So the language should clearly describe the type of ownership and license that you're being granted, what and how each of you are allowed to use each other's data, the system, the documents, and any intellectual property. Both parties should want it very clearly stated if and how each other use each other's names and logo, trademarks, and other copyrighted material. And if you are receiving a deliverable from the third-party vendor, then the contract should clearly indicate whether that deliverable does or does not become your property. So these are, at minimum, some things that should be considered in the ownership and license. And then as far as warranty goes, you know, most standard disclaimer or contract language has a disclaimer that the system is provided as is without any warranty whatsoever, but there are probably some reps and warranties that you're going to want to ensure are in the contract. That would include things like the third party that you're conducting business with has the necessary experience and certifications to do the job and perform the service, that they are in compliance with applicable laws, that they that their deliverables are materially conforming to the specifications that they provided. Those are just a number of the reps and warranties. There's probably other things that may need to be included as well. And then talking about indemnification clauses, an appropriately written one will hold your organization harmless from liability due to a negligent third party. Indemnification for infringement, breach of confidentiality, misuse of services, willful misconduct, gross negligence. These are all included in the indemnification clause. There's also standard language indemnifying against consequential and indirect damages. But the indemnification language is, pretty standard that you'll find from one contract to the next, but it is certainly something that needs to be reviewed by the appropriate people, legal generally, to ensure that it is something that is acceptable to you. At the same time, you want to be sure that you're reviewing that liability limit and determining whether the proposed limit is proportional to the amount of loss that you might experience with this particular vendor, especially as it relates to what data they have access to. So something to consider for limiting your liability is carving out certain provisions like infringement or breach of confidentiality or indemnification. Those are things that you typically find carved out of the liability limit. And again, a lot of situations you'll find standard contract language that has a minimum of $1,000 liability limit, and you typically find that negotiated. A little bit quicker through these last few slides about critical elements, but you want to include provisions around dispute resolution in the event that disputes do occur over payments or deliverables, etc. You want to include standards around incident management. Should an incident occur, what is an incident? First of all, how are they going to respond to it, and what time frame? What will they provide you as evidence that it's been resolved and they have a plan going forward? And then you would want to include some language around ongoing monitoring standards that on an annual basis or whatever the appropriate time period is, you are being provided with updated due diligence information about the vendor that you are doing business with. And this is a general catch-all of elements that you generally find at the end of any of these contracts. Things like survival, basically saying what elements, what provisions in this contract will extend beyond termination, such as confidentiality. There's other things as well. Governing law, again, talking about where if there are any disputes, they will be handled, how they'll be handled, in what state or what court. Severability, this means the one that contract provisions found to be invalid or void or unenforceable doesn't mean the entire contract is. Contract conflict, you might find this when there are multiple documents, as I had mentioned in MSA and SOW, and it indicates which one is the prevailing document, should there be conflicting language. Failure to exercise or waiver in general, this states that a right that hasn't been regularly enforced is a right that a court wouldn't enforce. So if you are a party who can enforce a right, you should include a waiver clause to ensure that you won't unintentionally lose your ability to do so in the future. It's complicated, very short provision. But again, these are ones that you will find generally at the end of every one of the standard contracts that I've seen anyway. So wow, that's a lot of provisions to review during the time you're putting that contract in place, as you're negotiating and reviewing all of the standards. But ongoing, you should be doing a midpoint review and ensure that there is, again, not changes that need to be made to this contract. Should something change regulatory-wise or privacy-wise, or just something that might have changed that would require you to negotiate in some different language. So this review and negotiation window for critical and high-risk contracts should be open at least 90 days before the contract expiration or renewal. So don't wait till the last moment. Begin reviewing this contract before the expiration date.
And this brings us to the first poll question of the day. You should see the poll question now in the slides area. If you have any issues, please feel free to send us a message using the Ask Question widget, and we will be happy to assist. As a quick reminder, if you wish to receive the CPE credit for today's session, you must answer all poll questions and be in attendance for the entire live session. This poll question is, Does your third-party risk management program include requirements or tasks to perform a thorough review of the critical elements of your contracts? Yes, we have a mandatory contract review process in place prior to signing. Some vendor contracts are reviewed prior to signing. We don't have a formalized contract review process, other or not sure. Kelly, we have some time now to answer a question from the audience. And this question is, when should you consider a contract renegotiation with a third party?
There's probably a couple of situations where you might want to consider that. One would be if your third party has continuous performance issues. It's certainly a great time to renegotiate the terms, likely renegotiate the service level agreement, look for some possible pricing concessions or other kinds of credits due to poor performance. So that would certainly be one time you would want to consider a renegotiation. Another time might be if you are, and we're all seeing this these days, experiencing some budget constraints and you're looking to kind of do a remix of what you have purchased from that vendor. That might be another time. Now, if you're the one requesting that, there may be things you have to give because it's always a give and take. And then certainly another time might be if there have been some recent changes in regulations. Good ones to point out are things like privacy laws that continue to pop up in various states. If you see things there and feel that your contract has some gaps in it because of changes in regulations, that would be another time when you may want to discuss a renegotiation with your third party. The key too is hopefully you have a partnership with that third party that they're going to be willing to renegotiate with you. It's not a requirement, of course, since you're in a contract.
Thank you, everyone, for answering that poll question. Here are the results. By the way, you may have noticed reactions such as a thumbs up or heart coming across the screen. If you find this feature distracting, you can turn it off by clicking the 4 arrows in the top right-hand corner of the slides widget, which will expand the slides to full screen and no longer show the reactions. Also, before we move on, in the related content widget, you will find our What to Consider for Vendor Contract Renegotiations or Amendments infographic. This is a handy resource to grab as it discusses different considerations for renegotiating a contract. Kelly, let's continue with the presentation.
So I mentioned this a few moments ago, but we're going to spend more time on this. And your standard should be that your third party is actively managing their third parties just as you are actively managing your third party. So you expect this of them because you don't have a contractual relationship with those fourth parties. So you are dependent on your third party to ensure that they're doing all of these things with their fourth party. So you want to include in your contract language that's requiring the third parties to review business continuity and disaster recovery plans with their third parties. Making sure that their information security and privacy program is in place and that they are reviewing that regularly, that they too are compliant with all applicable regulations and laws and rules. And again, your third party is managing their third parties just as you are managing yours. So they have an ongoing monitoring requirement in place with their fourth parties. So you can do this with one provision in the contract that's covering every area where the third party might be reviewing their fourth parties, your fourth party, their third party, or you could spread it out in the various sections. I've seen it both ways. And continuing on with the critical provisions that you want to ensure are covered to support the fourth parties that you have, again, is making sure that you know who those critical subcontractors are. Who are those critical fourth parties? And that word is interchangeable, of course. So at the time you are writing your contract and putting that in place with your third party, it's a good time to get a full disclosure of all fourth parties that have that are a part of whatever it is you're buying from that vendor and those who have access to your data. So that is critical to get that up front so you know who those critical subcontractors are, and you probably want to write into your contract that you will be notified, excuse me, should those fourth parties change. And again, back to audit rights, and we talked about that a moment ago, but when you are writing in your contract that you have the right to audit your third party, that needs to be extended beyond just the third party and into the fourth parties as well. So be sure to extend that right to audit language. Again, the bottom line is that you are holding your third party accountable for the actions of their subcontractors or your fourth parties. Other contract requirements to consider as it relates to fourth parties is adverse events. Again, because your reputation depends on your third party's reputation, and guess what? Their reputation depends on their third party's reputation. So you should be concerned about any adverse reputational, legal, or financial events of that fourth party. So to address this, the contract might stipulate that acceptable timeframes around notifying you of potential concerns with potential rights in the contract for you to require a different fourth party or a contract exit if that can't be changed. Ongoing monitoring requirements, I believe I mentioned that 2 slides ago, so I won't cover that again. And then your NDA, if you have a separate non-disclosure agreement with your third party, then you should ensure that that agreement also extends into your fourth parties. You may or may not have one because that language could also be covered within the terms and agreements. And to close this out, you certainly, again, want to make sure that insurance, we haven't talked about that. So you want to make sure that insurance is extended into the fourth party. So your third party insurance requirements that you have in place with them need to, again, be considerate, have into consideration the fourth parties that are providing that services to you as well. So while you may not get a COI on the fourth party, again, your third party coverage needs to cover that fourth party. Just a couple of other things is data. Let's talk about that for just a moment. When you terminate a contract with a third party, you also want to ensure that the data that is being used and handled by the fourth party also gets destroyed, if that's the expectation. If the third party is going to destroy the data, the fourth parties need to destroy the data as well. And you also need to, let's talk just a moment about offshore activities. This is certainly an area you will want to know about when you go into this contractual relationship with this third party is, are they relying on any offshore fourth parties, because there are other contractual language you probably need to have in place with that. So again, I went through these kind of quickly. There's so much to talk about with fourth parties, but hopefully this gives you a solid base on how to cover them in your contract language with your third parties.
Our second poll question of the day is, within your contracts, do you ensure your third-party vendors are actively managing their third parties, your fourth parties, to the same standards that you contractually expect of your third party? Yes, with all contracted third-party vendors. Yes, with some contracted third-party vendors. We don't require these fourth-party standards. Other or not sure. Kelly, I have another question here from the audience that we can answer. And this question is, who should draft an SLA with the third parties?
In a best situation, or a best practice, I should say, you would certainly want to include multiple people within the company and multiple people at the vendor when creating, reviewing, and approving the SLAs. It's certainly a collaborative relationship, and writing SLAs can be very cumbersome, very complicated, to make sure that you get it detailed succinctly so that ambiguity is removed from it. It's very difficult to write SLAs, and then there could be SLAs in a number of different ways within the product. So bringing in the people who truly have the understanding and the knowledge of the guts and operations of the product and the service is critical to have involved in that process. So you would want to pull in people that have that knowledge on both sides, both the vendor side and your side, as well as, your typical folks that are involved in writing contracts, whether that's legal or risk management, senior management, whomever that might be.
Okay, here are those results. Thanks again, everyone, for taking the time to answer the poll. Before moving on, I'd like to remind you that you will find our How to Write Fourth-Party Vendor Requirements into the Contract infographic in the Related Content widget. As Kelly just discussed fourth-party vendor contract considerations, you may want to check this out. Kelly, back to you.
Okay, let's turn our attention now to SLAs, KRIs, and KPIs. These are commonly used acronyms, really regardless of the industry, and each is a type of measurement or a quality assurance. So just want to be sure that we understand that these are essential parts of a contract with your third-party vendors, especially your critical third-party vendors. And it is a two-way street. A healthy, successful partnership requires that the expectations on your side are something that the other side can actually perform. So setting these SLAs must be a mutual agreement. So the service level agreement, or SLA, identifies the expected quality, delivery, and performance of your third party. In the best scenario, I think I mentioned, you might see this as an exhibit or an attachment that details out these SLAs very thoroughly. The SLAs may carry a penalty for noncompliance with your critical vendors. I would recommend that if that was negotiated in. If not, you should consider that in the future. When penalties are included, they can be monetary penalties, or they could be in the form of discounts or fines. They can also be non-monetary, such as losing the right to compete for more business. While it's not stated, if you continue to see performance issues, you probably aren't going to buy more from them. And the SLAs, when they are written properly, should include an ultimate result of terminating the contract should the SLAs be missed on a continuous basis, and ideally that would be spelled out very clearly. So a few characteristics of a good SLA is they will hold your vendor to a very high standard. The measurements and the thresholds and the penalties for noncompliance are clearly defined and not ambiguous. And a characteristic as well is that it helps protect your organization from penalties or fines that's caused because of you missing requirements with your customers or with regulatory authorities. So you benefit from proactive risk management. So not only are you going to monitor your vendors' risks, but their performance as well. And as part of that, you should be looking at things like their reputation, any negative news or financial condition. Do you find any areas of concern with the vendor? This additional analysis is basically where you are uncovering key risk indicators. Key risk indicators are the conditions where you might find reason to request additional details about something you've learned about them, want them to give you further analysis of what might have caused those situations. These are the bells ringing, right? These are suggesting a potential material risk could be brewing. KRIs are also set at such a level that both parties recognize that they need immediate attention, and they are beneficial to both parties. So a really good way to work through these and to talk through these and identify them are through establishing quarterly business reviews with your third parties. This is a great investigative, non-threatening way to talk through these events that might be occurring. So some characteristics of a good KRI are, knowing the details like the people, the processes, as much as you can about the technology and the facilities and the attributes that are very important to the continued operational success of that vendor or third party. Another one is identifying and ranking the risk, threats, and vulnerabilities, and then looking at the likelihood of any of them occurring, and then linking those attributes to the most significant risks so that you can identify those of greatest concern and always keep your eye on those. And then lastly, you have KPIs, or key performance indicators. KPIs are other measurements used in defining the overall performance level of the vendor. They should be objective, meaning that there is a definable measurement that can be supported by data. Your KPIs generally establish the specific day-to-day activity that is being monitored and measured to assess the performance of your vendor. And to monitor KPIs effectively, you need access to reports and data, whether they're provided by your third party or whether you have them yourselves. Either way, to make best use of these KPIs, you would have someone or multiple people who have the responsibility of monitoring these KPIs and escalating when necessary. Otherwise, why are you taking the time to establish these performance measurements in the contract in the first place? So again, make sure that these KPIs are objective. There are times when you may need to rely on some subjective ones, though. Some good examples is just, is there a lot of turnover within the support team or within management? Are they keeping established meetings? These kinds of things, that decline in support, these are the kinds of things that are subjective but lead you down a path of performance concerns. So none of this is new news to any of you, but a characteristic of a good performance indicator or KPI is keeping it simple so that it's easily understood, making it relevant because it should be important to your organization, making sure that it is quantifiable and verifiable. Achievable is very important, making sure that it is timely so that it allows feedback and correction, and that it is visible to the relevant stakeholders. Very simply, but these are things we all know. I've mentioned this throughout the last few slides, but just again to identify the difference, there are objective and subjective KRIs and KPIs. Objective ones, of course, refer to something that can be counted and measured. Some examples are number of high-risk vendors, time to complete a risk assessment, percentage of critical vendors, volume of customer complaints. Subjective ones are qualitative, or something that's observed or experienced or felt, includes opinions and expressions, and some examples might include stakeholder satisfaction, maybe ease of use, usefulness of reporting, but they don't have the numbers necessarily, the quantitative numbers behind them. And to finish up on this topic, this is an example of an objective KRI. Would be service availability. If the SLA states that the service must be available 98% of the time, as an example, and there's been a recent pattern where that hasn't been met, then that's an example of an objective. It's measurable, it's timely, it's specific. An example of a subjective KPI would be, say, suitability. Suppose your vendor replaces your account manager with someone who doesn't seem knowledgeable about your business and has less experience, and therefore you don't feel like you're getting the service you were getting. That, again, is a subjective KPI that could lead to something further down the road. So here we are at the end of the contract where we either need to or want to exit the relationship. And so an exit strategy just means that you're leaving the current situation, and whether you determine that up front or something happened that's causing you to leave it as an unplanned incident or default situation, whatever the case may be, this is where you need to work through a strategy to ensure that you are exiting the vendor, the third party, appropriately and taking everything into consideration. You're going to take things like What's going to happen to your data after you leave? What are you doing to then replace this? Are you bringing this function in-house? Are you looking for a new vendor to replace it? What is the timeline when all of that needs to happen so that there is zero or minimum disruption to the service, whether that's service to your customers or service to you internally, whatever it is. Consider all of the alternatives, whether this is a slow unwind because you, again, made the decision you're going to leave this vendor, or a hasty plan because you had no choice but to leave this vendor. And make sure that your exit strategy is thought out, reviewed, and if possible, tested. And it's unlikely that you'll have answers to all these questions when you are writing the contract with a new vendor, but you need to have thought through what that exit strategy would look like when that time comes. And one thing you really should be doing with each one of your critical vendors is ensuring that they understand you will go through a mini vendor selection process every time your vendor's contract is up for renewal. It's always healthy to shop. So stay current on competitive solutions and just good sound business strategy to make sure you're putting all of your vendors on notice that performance is being evaluated throughout that contract. When you are negotiating the contract, though, hopefully you did include language to support that transitional period when it does come time to end the relationship. So you want to make sure you're covering how long they're going to support you, again, what happens with the documents and the data, what each party's responsibilities are with the transition, what level of service they will provide you. All of that should be talked about during the contract phase, and much of it included in the actual contract. And just two more points to make as it relates to an exit strategy to consider during contract in your contract is maintaining that data security and privacy. Again, even during the transition from one vendor to the next, just be sure that that is thought about and agreed upon in the contract. Because again, just because you left that vendor doesn't mean you should be concerned about the security and privacy of your data. So you want to make sure that is covered. And lastly is, will there be any deconversion costs? So you need to think about that and, make sure that is documented in the contract. And if there is some kind of cost associated with it, it may not be identified in the contract, but at least you'll know going into the contract that you could expect some type of cost associated with the transition.
Our third and final poll question is, what type of exit strategy and preparation do you have in place for your third-party vendors? The sudden loss of a third party? The intended gradual unwind of a third party? Both exit types? We don't have exit strategies in place? Other or not sure? Kelly, let's go ahead and answer another question from the audience. And this next question is, what responsibility does my company have with managing our fourth parties?
Well, first of all, you don't have a contractual relationship, remember, with your fourth party, so you can't. So there's things you can't do, I guess, with that fourth party, unless the fourth party is willing to work with you. Depending on the industry that you are in, I can speak to, specifically to financial institutions. There definitely is some regulatory requirement to having a review of fourth parties, and that it can be found in the interagency guidelines. And I'm certain in other industries there's probably there as well. But because you do have a contractual relationship with the third party, and you know that that third party is sharing data with the fourth party that's providing the service, then really your obligation is with the third party, your contractual obligation is with the third party for them to be managing the fourth parties. And in some situations, you may have it written into your contract that the third party provides you fourth party data, depending on who that fourth party might be, fourth party due diligence, fourth party ongoing monitoring, results from your third party. So you have the responsibility in certain industries. It just depends on how you go about getting that from the third party and how you contractually obligate your third party to get that to you. And here are those results. Thank you, everyone, for answering this question.
Before continuing, I would like to mention that in the related content widget, we have our How to Develop Metrics in Your Third-Party Risk Management Program infographic. As we just discussed KPIs and KRIs, this is a great resource to grab and reference. Let's continue with the presentation. Back to you, Kelly.
For the next 6 or 7 slides, I can't remember the count, I am providing some sample contract language for the majority of the provisions we've been talking about. So I'm not going to sit here and read through each of these because each of you will have access to this presentation following this webinar. But just see on this slide, you'll see audit, assignment, and indemnification languages or provisions. And then we have a general clause covering subcontractors. And remember, I mentioned a few slides back that you might have one clause that covers it all, or you may have it scattered throughout the contract. So here's one clause, as well as a clause around general compliance requirements with the agreement. And then here's that standard clause you typically see with disclaimers of warranties. Here's one for mutual warranties, and then here's another one that covers some warranties. So a good sampling of how warranties could be covered in a variety of ways. I talked about this in detail when we talked about exit strategies, but here's a provision sample for transition services or a transition plan, because remember we talked about all these contracts typically will end at some point, and you need to make sure that is covered in the contract going in, what the expectations are when leaving the relationship. So this clause, termination for cause, is a good example of a language that should be included in the event that there is a reason for ceasing the relationship based on cause, based on a breach or a failure to perform or some reason like that. This is often a one-sided agreement or a one-sided clause, but can be made mutual as well. And then here's a sample clause on insurance requirements. It's a very generic clause, not speaking to specific levels of insurance, but you probably do want to get to certain levels of insurance requirements with your critical vendors. And then one on licensing to use trademarks, which again is very, very important to have detailed in the contract so that everyone knows what they can do with each other's owned rights. And the last one to include here is dispute resolution with arbitration. And again, I did not cover all of the contract clauses or potential contract clauses. I just provided some sample clauses for a subset of them. So I just want to make sure that it's clear that you won't get all of them. A couple of final comments on contract clauses. Be sure to track any standard clauses that you negotiated out of a contract. This can certainly help save some time for the vendor owners and legal teams if legal issues do arise with that vendor. And also it contributes to a more holistic view of the vendor risk profile when you know exactly what terms you agreed to negotiate out that you would typically keep in. Here's a few helpful tips to create a clause library. One is refer to the regulations. Again, search the important provisions based on your regulatory requirements for guidance. For example, the FDIC for managing third-party risk, HIPAA, and HHS, which is business associate contracts, and a sample business associate agreement provisions. The OCC, also the third-party risk relationships, risk management guidance, will provide these contract language requirements, as well as the FFIEC, the Information Technology Examination Handbook, as well as the interagency guidelines, which is not mentioned on this. And there are likely others depending on your industry that you are in and the regulations that you have to observe. Also, consider reputable organizations. You can look at the American Bar Association for sample contracts, and there's probably others out there that you could search, such as Google and others. Save approved contract clauses. I do that as well. I have a list of approved contract clauses so that I know what I can safely negotiate out. And then that will help you in the future. And stay informed of regulatory changes, because these regulatory changes, of course, could change some of your already pre-approved sample clauses. And then lastly, we always end with key takeaways. So we'll run through these quickly. Again, document the process for vendor contract management within your vendor management program. Plan the negotiation and strategy before you begin a vendor engagement, and you want to identify all the areas in the organization that should be involved in that process. Manage the risks, and hopefully you identified those risks during the contract management process, prior to the contract management process actually. Understand that contract management doesn't end once you sign that contract. It should be an ongoing responsibility, as well as managing the vendor ongoing. Understand that those termination provisions and what they are, to avoid unwanted renewals specifically, and consider writing fourth-party requirements into your third-party contracts. And then actively manage the delivery of the product or service against those established service level agreements that you hopefully have in place. Monitor the performance to them, as I just said. Make sure the procedures for dispute resolution are clearly defined, and that you have put exit strategies in place should it come to needing to leave that contractual relationship, and create an acceptable and approved library of contract clauses. Well, that was a lot in this webinar. I hope it was very helpful to you. And with that, I'm going to turn it back over to Jessie.
Great, thank you so much, Kelly. Before we dive into more questions and answers, I would like to thank everyone for attending. I would also like to thank Kelly for her time in sharing some important information. On your screen now, you will see our upcoming webinars. On May 21st, our Strategies to Mature Your Vendor Risk Management Program webinar. And on June 4th, our Vendor Complementary User Entity Controls, What They Are and How to Use Them to Protect Your Organization webinar. We hope you'll be able to join us for those sessions. A link to register for those is in your copy of today's presentation slides. We'll now go ahead and answer some more questions that have come in during the session. Okay, Kelly, our next question is, given the rapid growth of AI and the issues related to that, both AI hallucinations and growing regulations, should language about use of AI or use of data to training an AI large language model be one of the key sections to include in contracts?
Yeah, and that is such a great and relevant question that I wish I had a one-size-fits-all answer, but I don't. I'm going to be very honest with you and tell you that we have not yet added any standard clause to our contracts around AI. We know we need to, we just haven't done it yet. So I'm just going to be very honest about that. It's an emerging market, as we all know, emerging industry, or not industry, but technology, as we all know. And we have been presented with language in contracts that are not our contracts. And we have always engaged our outside legal counsel, because there's just too many unknowns around all of it right now. So I really don't have an answer other than, yes, it is emerging. It's emerging quickly. And so it is very important to have a stance, to have an idea of what your stance should be when you're presented with it. And if you do have contract templates that you lead with, to absolutely have some language in there, whether it's addressing what you're doing with AI, or what you expect or don't expect of the third party, the provider that you're contracting with, to do with AI. So that's a long-winded answer to say I don't really have an answer, but it is something that all of us need to be looking at right now for certain.
Great. Our next question. What if critical supplier refuses to share disaster recovery test results and/or subcontractor information?
Yeah, and that will happen. As far as disaster recovery results go, what they may not provide to you are detailed results, but they may provide an executive summary. So that's an option to request. As far as subcontractor information, I mean, it's just becoming such an important part of due diligence and ongoing monitoring with third parties, and so many regulations are picking up more and more and requiring more and more with it, that is just these third-party vendors and suppliers that are refusing to participate have to eventually figure out that they have to participate in one way or another. So while maybe they may not provide documents, maybe they will agree to a conference call, a video call between the subcontractor that you're most interested in, or subcontractors themselves and you, so that they can answer questions, maybe share some documentation online so that you can view some things in it versus actually getting documents. So there's a couple of examples of ways to do it. And then in the end, I think it just comes down to, are there other vendors who you could work with that provide the same service that you may need to be thinking about? That goes back to, the exit strategy and knowing when you need to leave a vendor and having a plan for doing that, including, not being willing to provide appropriate information about their subcontractors, especially if your data is with that subcontractor. So it's a hard conversation, but one that really needs to take place.
Great. Our next question. If we have a contract that is set to auto-renew, how often should we do a full contract review? Annually, every 3 years, or every 5 years?
I would still suggest, if it's a critical vendor or vendor that has access to your data, that you review it annually, even if it's a 3-year contract and it has an auto-renew and you're just into year 1. I would suggest it still should be reviewed, because you should be reviewing the contract to ensure that the vendor is, complying with all of the responsibilities that they were supposed to comply with, especially as it relates to performance, deliverables, reports, data, whatever it might be. So, it might be a really quick review of the contract and say, okay, nothing's changed, we're all good. But I would still suggest it be a line item that an effort is made to review it, even if it's not up for renewal, and even if it's several years out before it is.
Great. We have time for one more quick question. Are purchase orders considered a type of contract?
Yeah, they are technically considered a contract, but it really only, from my research into this and from what I've experienced, it really only becomes a legally binding document if the seller accepts the terms of that purchase order by signing it, and the seller provides and delivers what was purchased. And so then it becomes a legally binding contract. What I have seen in experience is that the purchase order most of them would include a link to online terms that is, that's where that, back to the negotiation statement that I said, there may be times you have to go into a relationship with a vendor and you didn't really get a chance to negotiate the terms. They said, take it or leave it. I mean, that is probably likely one of those situations that the terms are embedded in that purchase order. And so by you agreeing to that purchase order, you're agreeing to those terms. You didn't get a chance to negotiate them. So yes, by my research, it is a contract as long as those two things take place. The seller signs it and the seller delivers. It's a contract.
Great. Thank you, Kelly. Unfortunately, that is all the time we have left for questions today. Thank you, Kelly, for taking the time to address some of those that came in. Any questions we did not have time to answer today, we will address offline. We would like to thank you all for attending and hope you found today's session valuable. Another big thank you to Kelly for her time and content. You can ask even more questions inside of our third-party think tank, an online community that is dedicated to third-party risk professionals and free to join. Just because today's session has ended doesn't mean the conversations and questions must. Post your questions at thirdpartythinktank.com and see what your peers have to say. In the community, you'll find thousands of free educational resources, including ones related to vendor contract reviews. If you would like to become a member of Third Party Think Tank, you can register on the site or shoot us an email and we'll get you registered and send you a link to set your password. We did record today's session, and that recording link will be provided to you in a follow-up email that you will receive tomorrow afternoon. Also in the follow-up email will be the survey link for you to request the CPE credit. On behalf of VendMinder, it has been a pleasure. Thank you and have a great rest of your day.